Hi, I'm Donald Goldbloom, attorney at law. I've been helping clients with legal matters for over 40 years. While this video serves to provide some general information around the practice areas discussed, it should not be taken as legal advice and should also consult directly with an attorney to make sure that the specifics of your particular matter match up with the various laws that are applicable. The choice of an attorney is an important decision and should be given careful thought before deciding on who you may wish to hire. If you need representation or have any questions, don't hesitate to contact me at 301 895 5240 or visit our firm's website at www.goldbloomlaw.com. That's GOLD, like the metal gold, and Bloom, BLOOM, like a flower blooms, goldbloomlaw.com.
All right, so I am back again with Donald Goldbloom, an attorney in Grantsville, Maryland, and today's topic will be bankruptcy law. We're going to be giving a brief overview of the bankruptcy process in Maryland, and we might touch a little bit into Pennsylvania as well, but just overall kind of how bankruptcy looks and how it works for people. Don, thank you for being with me today.
I'm glad to be with you.
All right, so we're just going to start off with the most basic question that I can provide, which is, can you provide us with a basic explanation of bankruptcy?
Well, bankruptcy is relief for somebody that gets in over their head with debt and they can't pay their bills. And it is designed for people where this has happened through no direct or intentional fault of their own. Really, I always tell people that bankruptcy goes back to as far back as biblical times, when, if you go through the Old Testament, people that couldn't pay their bills would then be an indentured servant for 6 years, and the seventh year was a Jubilee year, and they were set free. So there has always been a concept throughout most advanced civilizations to um, have people have a fresh start. And the feeling behind that is because in the studies that I've been familiar with, the most common types of bankruptcies are caused by divorce, they're caused by unemployment, or they're caused by sickness. Only about maybe 20% are gross mismanagement of money. Now, the best manager of money will manage their resources so that it will withstand divorce, unemployment, um, and sickness. But if we're the run of the mill people, we are not um, Warren Buffett. We are not um, off the chart in terms of those special good habits and everything, where no matter what happens, we're going to survive. We're just plain normal citizens. About half the country is living paycheck to paycheck. And these unfortunate things happen, and therefore someone would need a fresh start. The alternative to that would be debtors' prisons, and it can cost over $80,000 a year to incarcerate somebody. So if you put somebody in prison because they owe money, the state is paying $80,000 a year to give them their room and board in the prison, and they're not working, so they're not paying taxes. So if they were working a $60,000 job that they're not working because they're in jail, then maybe 20% of that would be taxes. So if you add the 20% that the state's losing there, plus the $80,000 it's costing to put the person in jail, that's a shortfall to society of $100,000. Isn't it a lot better to give that person a fresh start? So the idea of bankruptcy is to balance the person's ability to have forgiveness and get a fresh start versus the ability of a creditor to be paid. Because the creditors were paid on a regular basis, they'll economic system would fall apart. If people were not allowed to get a fresh start, you would have a huge burden to society by carrying people that could otherwise rehabilitate and be good productive members. So the concept of bankruptcy is getting discharged from most debts. That's what happens in a bankruptcy. The debts are discharged. You no longer have to pay them. Um, and you are balancing that fresh start concept versus the right of the creditors to be paid. And it's where you have the intersection of those two goals that you find your work in bankruptcy and what I find most rewarding about my work in bankruptcy.
I appreciate that, and I appreciate you also providing some numbers. I think the percentages at the beginning where you provided, a general outline for the percent of people that actually go through bankruptcy due to mismanagement of money is important for a lot of people to recognize and see. Because sometimes there's still some stigma to bankruptcy, and also for people that kind of feel ashamed or embarrassed to go through it, that for a majority of those that are seeking you, it probably, in most cases, outside of their control that they have to be going through and filing bankruptcy. And most people who are filing bankruptcy don't want to be filing bankruptcy, and they don't want to be in the state that they're in right now. A lot of people are very productive, and just like you said, some circumstances come up that put them where they are, but they're still hard workers, and they want to, you know they are contributing, and they want to continue to contribute to society, and be a part and do everything with everyone. So having that option for relief is a very good thing that our system entails, and allows for many people.
In a rural practice, I practice in an area that um, is quite conservative in terms of um, in ethics and religion and a lot of shame. And those that are the most concerned about that, I say, if they'll say, well, my maker is really that higher power above. It's not part of our secular world, but part of their world. And I will say that, well, what I'm going to do is give you relief through the law, through our secular law, that buys you time to get back on your feet. And if from a religious standpoint or a moral standpoint, you want to pay these people back, there's nothing preventing you from voluntarily paying every penny that you owe. But you were given a time to rehabilitate yourself and the ability to pay that. Now, as a practical matter, I'm not finding that many people do that, but some do. They very, very, so you're not foreclosing someone's ability to follow to the letter the most orthodox of religions that are mandating that you really pay everything back. But they can do it in a way that they can also taking the parts of those religions that do provide for forgiveness and a fresh start. So while we are in the secular world, a secular society, our laws and our constitution and framework is based on a lot of those influences in Western culture.
And to build on that, and to kind of go into kind of my next topic, and I think you kind of set it up as a great segue with that point right there, where people, a lot of them want to pay off their debt. They want to continue with that, and there are options of bankruptcy. With, I think the phrase you used was relief, or even temporary relief, which basically helps them get back on their feet, and they still have the option to pay back their debt if they want. It just kind of postpones kind of what is going through and going on in their lives in the process, so they can get to that point, so they are stable again, so they can do that if they would like to. um can you talk a bit about the different types of bankruptcy that someone might go through, and how that would impact them, and how it might do that as well? Where there's types that can, like you mentioned, discharge debt, what debt is discharged, and types of bankruptcy that you temporarily, you're still paying, but to maybe a lesser degree while you're going through that bankruptcy process. Can you talk a bit about the types of bankruptcy and what they mean for people that file for them?
Well, first, let me go over the types of debt that are discharged, because a type of bankruptcy is not There's some differences between the types of bankruptcy and the type of debt that's discharged. But for the general purposes of this interview, there are not that many differences in the types of debts that are discharged versus the type of bankruptcy that you're filing. Where there are some differences is then I can explain them to you in detail. But so again, I'll start with the types of debts that are discharged. Most back taxes are not discharged. You have to say death and taxes. However, taxes over 4 years, if you filed on time, if you did everything, the only thing you did is you couldn't pay, but you did file, and all the technical filing requirements and whatnot are kept. A lot of older taxes can be discharged, but but once they've gone to judgment or there's a lien, a tax lien, well, that doesn't go away because that's already attached to your land. Bankruptcy goes to your personal, attaching your personal wages or your personal ability to pay. So if there's already a lien against property, it's not going to relieve that. But a lot of people have old taxes and they think, oh, well, just back taxes, I can't get out of them. There are some back taxes you can get out of. But a lot of people are thinking of taxes within the last 4 years. No, you're not going to get out of a lot of taxes. You're not going to get out of things that you did intentionally to people. So if I intentionally looked at your chair and I realized that it's 8.6 inches, and I have just enough room to get a baseball bat and knock you over the head, and you sue me for battery, you sue me for $500,000 because I've ruined your career. You can't interview me anymore. Okay, then that bankruptcy ain't going to help me because it's an intentional. I also probably go to jail for that too. But assuming that I got some beautiful lawyer that got me out of the criminal case, as you could see with some of the high profile cases, I think O.J. Simpson got out of the murder, but he didn't get out of the civil penalty for wrongful death. Okay. So my wonderful downstate lawyer found that there was a technicality and I didn't go to jail because I beat you up with a baseball bat, but you sued me for that. I'm not going to get out of that in bankruptcy because it's an intentional act. So just think of it in terms of fraud. Bankruptcy is not going to relieve me. Intentionally harming somebody, not going to relieve me. Libel, slander, all these what we call intentional torts. Because bankruptcy isn't to let me off of wrongdoers, it's to give me a fresh start. So it makes perfect sense if you're thinking in grand scheme what bankruptcy covers and what it doesn't cover. Also, drunken driving. If I injure you as a result of drinking and driving, while it doesn't have the specific intent to me beating you over the baseball bat does, society says that when you get alcohol in you, you get behind that wheel, you are recklessly endangering the rest of society, and you could be, killing them. And so you got somebody that's injured from DWI. In a lot of cases, that's not going to be discharged. The other thing, most student loans are not dischargeable in bankruptcy because you had doctors and lawyers writing up all kinds of $200,000-300,000 worth of bills, and they were smart enough to know how to file bankruptcy, and so that created a problem. Now you have the reverse effect. People are getting so in debt with student loans, they'll never really get out. But then you need to hire an attorney that specializes in dealing with student loans because there are forgiveness programs and there are ways to work through it. There's also hardship issues, and there is hardship in bankruptcy. It is harder to get through bankruptcy than it is through the student loan program. Most student loans are not going to be covered in bankruptcy. So just to think of it, things that you intentionally do, like committing fraud or harming somebody, are not going to be discharged. Most back taxes are not going to be discharged, and student loans are not discharged. And this is general. Now, there's little exceptions and things, but this is a general way of looking at it. So that means Most other debts that you have, which usually is credit card bills and those kinds of things, are can be discharged. And so that's the first level, is what gets discharged. Then you get into the two types of bankruptcies. One is Chapter 7 and one is Chapter 13. There are two other types of bankruptcies. Chapter 11, which is reorganization for people with large debts, large sums of money, usually businesses or corporations. They're not totally getting rid of their debt, they're reorganizing their debt. And there's Chapter 12, which is for family farmers and fishermen, that are a special type of reorganization to keep them in business and keep them doing their farming and fishing. Most bankruptcies that we're going to be talking about are Chapter 7 and Chapter 13. Chapter 7 is where you just go flat broke. You are allowed to keep, each state has exemptions. The federal law has exemptions, and it goes state by state, because primarily the federal law is going to follow the state law in terms of what you are allowed to keep. They literally do not take the shirt off your back. You can keep the clothes that you're wearing. You can keep up to a degree the car that you're driving and those kinds of things. So rather than, and I do practice some in southwest Pennsylvania, I practice in Maryland with bankruptcy. The two states are a little bit different in their exemptions. So let me just tell you, from a general point of view, you can keep at least some money towards the home that you live in. You can keep your general clothes and general personal effects, some level of cash. And what these are what we call exemptions. They don't take them from you, but if you have what's over those exemptions, they can take from you, sell it, and the proceeds then go back to pay the people you owe the money to. So if you have if I have a equity in a house, I have a large amount that a house that's all paid for, and I have $30,000 in credit card. Well, in Maryland, I think um, we just went to, I might keep maybe thirty to $40,000 of exemption on the real estate. But if my equity is 200,000, I don't want to lose my house by filing a Chapter 7. So what I'm going to do is, so there's two types of Chapter 7. There's an asset case and a non-asset case. Most of my Chapter 7s are what I call no asset Chapter 7s. In other words, there's nothing, when you take the exemptions, what you're allowed to keep, there's nothing left over for the creditors to take. So this closed out as a no asset Chapter 7 case. Person walks scot-free and they get their fresh start. An asset Chapter 7 is where there is property left over. That is sold off by the trustee, and then maybe the creditor is only going to get 10 cents or 15 cents on the dollar, but they will get something back. Then there's Chapter 13. And let's say I have equity in a house. I've got $30,000 in credit card I can't pay. Well, then I don't want to lose my house. So I will do a 3 to 5 year repayment plan through a Chapter 13. This way, in this particular example, the creditors are going to get all their money back, but they're going to get it back over a 3 to 5 year period. But then I get to keep my house. I'm not worried about staying within the exemptions. I'm getting the creditors paid back without them coming in and taking it from me. So Chapter 13 is a way to get relief where I have assets that would be more than what I could do in a Chapter 7 without the trustee selling everything off. There also are advantages to Chapter 13 when you're trying to work out tax debt. Maybe the IRS isn't going to be real amenable to the way you want to pay back your taxes, but in a Chapter 13, you can pay them over a 3 to 5 year period of time. And that's, again, it stops tax garnishments. A lot of sometimes somebody will come in 2 days before they're going to garnish their wages. I have doctors came into my practice and I've titled Chapter 13, and then it makes them pay it out over a 3 to 5 year period of time, rather than the poor doctor not being able to practice medicine the next day because he's out of business because it's been garnished. So those are the two types that consumers are worried about. And what I'm addressing today is consumer bankruptcy. Business bankruptcy is a whole other field. And it's something that other lawyers do, but what I advertise, I'm doing mainly consumer bankruptcies.
I think that was a very good overview of the different types and good knowledge on both the Chapter 7 and Chapter 13 portions of bankruptcy. Tying into that, and I think you actually did cover this in your topic, but I just want to reiterate it because this is a very common question that I know people uh, search and are curious about when going through bankruptcy is, can bankruptcy save my home or my car? And it sounds like the answer to that is yes, it can. But there are rules to it, and you want to seek an attorney who can help walk you through the process to make sure that you're doing the right things when filing to make sure that you keep your home and your car. Correct?
Absolutely. And again, by doing this, sometimes they can keep their home and still file a Chapter 7 because instead of my house being paid for, um, I'm making, let's say I only have 10,000 in equity. I just bought the house maybe a year ago, and it's a $200,000 house, and I still owe 190,000 on it. So, towards my exemptions, 10,000, I have way more than $10,000 that I can keep towards my homestead in Maryland or even Pennsylvania. So I can keep it because it really the bank has the interest, secured interest in it. So it's going to go back to the bank, and the bank would stand in priority over the unsecured creditors, the credit cards. So as long as I satisfy the bank and we keep making payments, we're current on the payments, I'm going to keep that house and still file a Chapter 7 because it's not an asset that the general creditors are going to get. The bank's going to take it back. So I'm saved that house because if I just get judgment against me and I can't make my house payment, then eventually they'll come in and foreclose. Now, sometimes I haven't made my house payments for a long time, 6 months arrears, and the hammer's going to come down. In that time, in that instance, I might be filing a Chapter 13 because I might have 60,000 in arrears or 10,000 in arrears, some in arrears. And by getting rid of my credit cards and all the other unsecured debt, I can make a monthly payment towards the arrears and my house payment if I don't have to pay all the other bills. And that way I've saved my house from the auctioneer laying down the hammer and having it go through a foreclosure. Same thing with vehicles. So there's all kinds of ramifications of way that you can jimmy down the value of certain things in a Chapter 13 and a lot of details that you would have to have a lawyer explain to you. But just overall, it is very common to save a vehicle or a house through bankruptcy as long as your repayment plan is realistic and getting rid of all the other debt, you can continue to meet those obligations and you have the income coming in order to sustain it.
Building on that point and kind of everything we've covered through bankruptcy as a whole, if I'm going to you for the first time, uh, or maybe as this point the second time, I've already talked to you at some point through a consultation, and you think a bankruptcy might be an option for me. What documents should I bring you, and what documents do I need, or do you need in order to assess me to determine if I'm a good candidate for bankruptcy as a whole, or Chapter 7 and Chapter 13? What do you look for, and what do the courts need in order to have filed in order to file for bankruptcy?
Everything that would document the property that you own, that's what we call assets, and everything that documents the debt that you have, those are your bills, and everything that documents the income that you're making and what you've done over the last several years. So, 4 years of income tax returns is typical. 6 months of bank statements is what's usually required. Your 6 months of worth of pay stubs, and of course your tax returns will show, and your W-2s will show your income over the past several years. Then everything then that relates to documenting what you own. So that would be titles to vehicles, deeds to your house, um, and those things that you're not going to photograph every little thing you have in your home, but you're going to bring in a list of the things that you have in your house, the property that you have. Those are the main documents that we need. And just in short way of looking at it, what proves your income, what proves the what you own and what you owe.
How long does it end up taking in that case to file for bankruptcy once you have all these documents? And is there a filing cost to file for bankruptcy in Maryland and in Pennsylvania?
While there is a cost, and rather than me giving specific, because it's a little bit different if it's a joint bankruptcy versus a single bankruptcy, and there's, but I can just say it's in the range. Filing fee at this point uh, is a little over about a little under $340. It's 338. Um, I just say generally it's around $340 filing fee on a Chapter 7, and it's around 313 for Chapter 13 at this time. Rather than giving those specific numbers because they change all the time. So I would just say several $100s of filing fee for a Chapter 7 or 13, and that goes to the court. That is what you pay to the court. There's certain fee to take the debtor education course and a debtor counseling course. You have to take those two courses, counseling before you file the bankruptcy, and to make sure the bankruptcy is the right thing for you. Debtor education, it's like driver's education, so that you don't less likely to do this again because it teaches you about how to manage your money better. Those have fixed costs. And so before we even look at the attorney's fees, which vary depending on the attorney and the complexity of the case, you have sort of those fixed costs to get you in the court.
So the next part is after you're filing, how long does it take to file and before the bankruptcy actually kind of takes effect for people?
Okay, well, let me just say then, just to sum up on the cost, it costs several $100s that you pay to the court just to file. Um, typically, um, typically the fee is going to be um, a, you're going to pay the attorney commensurate with his skill. The attorneys try to be reasonable, and as a matter of fact, the courts have suggested upper limits on what attorneys can charge without justification of contested matters. So you do have the attorney's costs and the filing fees to get you in. Um, People and attorneys usually do require that up front, and they will put it in their trust account until they actually earn it, get the case filed. But the reason they require it up front is because once you file bankruptcy, you're going to be winding up going bankrupt on the attorney too if he's got bills out there for that work. And obviously, you're going to have to pay a lump sum usually. And in Chapter 13, you may not be paying as high a lump sum because you can schedule the attorney's fee payments in with your monthly payment. So that's something too that people think about. So you try not to be too scared by the amount of money it's going to cost the attorney, because there are creative ways we can work through that. Oftentimes, people might have a family member or a little bit of savings they could pay on a one-time basis to pay the attorney, but it's not going to sustain them to if they're upside down in their bills. Now, the length of time that it takes for this to go forward in what we call a no asset Chapter 7 typically takes about 4 or 5 months from beginning to end. That's from the day they walked into my office to the day they come out and they have that discharge, which means the debts are forgiven. Typically, if it's not an emergency type of case, I can usually turn my cases around anywhere from 1 to 3 or 4 weeks, depending on how quickly the clients bring in the documents. I always tell people that I do them in the order that they get the documents completed and to me rather than the order in which they come in. Sometimes people just really bad about getting me stuff, and I can't finish it without the right documents. But assuming on an average, usually a couple of weeks from the time they come in to get the documents and have it prepared and then get it filed. Once the case is filed, it's usually from anywhere from 3 to 8 weeks, typically about 5 or 6 weeks before we see the trustee. And it's what we call a first meeting of creditors. And they call it a section 341 because that's the code number for it. So sometimes in short, we call that a 341 meeting. It's where the creditors have the opportunity to come and talk to the debtor and get more information from the debtor. And it's the opportunity for the trustee to review the filings because the trustee is acting on behalf of the creditors. They call them an interim trustee on behalf of the creditors. So he wants to make sure that everybody's telling the truth and all the information is out there. Typically in a no asset chapter 7, creditors aren't going to bother to show because you'll already see by the filing that the client has nothing above the amount that they're allowed to keep, and there's nothing there for the creditors to get, and it's a waste of time to go to the meeting. So in a no asset case, usually creditors are not appearing. It's just the trustee. The trustee will review everything to make sure everything's correctly filed and nothing's missing. These days, that's done by Zoom. You used to have to go all the way to the court. Now, I'm doing this in Western Maryland. I'd have to go to Hagerstown or in a Chapter 13, go all the way to Greenbelt, where the court is located, or where the satellite office is located. Now, so after COVID, they are doing the routine meetings of creditors by Zoom. So the client doesn't have to go any further than my office. And technically, if they're tech savvy, they can do it from their home. But I like them to come in the office because I can be there with them to advise them, prepare them for their meeting. So that's going to happen 3 to 8 weeks, usually about 5 weeks after filing. Then there's a 60-day period after that when creditors have the right to file an objection, or the trustee can file an objection. Maybe all the paperwork isn't filed properly. Maybe there's missing things. Maybe, we found a ring that we thought it was worthless and it's worth several $1,000s, and now it's going to be an asset case rather than a no asset case. So that 60-day period runs. After that 60-day period, if nobody's filed any objections, then the trustee closes this case out as a no asset case and they get their discharge. So typically 4 months or so from beginning to end.
Okay, I think that's a pretty good estimation and a good period of time kind of for the case, and for everything involved in it.
I do want to say, however, that things are frozen as of the day I'm filing. So, for example, if there's a wage garnishment, that garnishment will stop as of the day I filed. I won't get the discharge for 4 months or 3 months because I've already used one of the months to prepare everything. But that garnishment stops. And actually, in a garnishment, you have a right to get 90 days prior to filing back refunded. So again, if they're going to foreclose in your home, the day you file freezes everything. It's what they call an automatic stay. Stay means stopping the proceedings, the collection proceedings, until we have time to see whether the bankruptcy is going to be approved or dismissed.
That's a very important detail, and I'm glad that you mentioned that, because that's one of the ultimate fears for a lot of people is having a wage garnishment, like you said, or that foreclosure, and the fact that they know that once you've entered, that will stop the process. Hopefully, that will help a lot of people, get their documents and everything together. That way, even though the full process might take 3, 4, 6 months time, if you can get everything sorted so that you can enter and appear on it, you can at least rest easy in terms of your wage and your assets being seized at that point.
Absolutely, and with dire emergencies. If you've had people, I discourage it, but they'll come to see me when they see me. So sometimes, they're coming the day before the foreclosure. I can get a skeleton case filed, emergency pleading filed, that is a petition for bankruptcy and a list of the creditors. And then I have 2 weeks to file all the rest of my schedules and get all the documentation in. So the key is, again, like in my criminal cases, the earlier you get the attorney, the better. But there is a way, if you're really in a desperate situation, to get things at least stayed or stopped until you can marshal everything. And then it goes through the process. Now, I might say that a Chapter 13 can take 3 to 5 years to complete. Usually, it's still going to be that same 4 month process to get through the meeting of creditors and to get the plan approved. And then the plan, though, will go on for those 3 to 5 years, which is why they're more expensive because you have more attorney time in it. You're looking at it over a 3 to 5 year period of time rather than just in and out. So in both chapters, your initial process is usually about 4 months, but a chapter 13, of course, goes on for the length of time that you're going to make the payments, whereas the 7 just closes up. Now, if it's an asset 7, it'll stay open until the property is sold and distributed to creditors. But in terms of you doing anything, it won't be past the 4 month period.
Gotcha. Gotcha. Now, I want to briefly cover, um, or a common question I should be kind of stating that kind of ties into actually something you mentioned before, which is you mentioned something about there's a difference between single and joint bankruptcy. So, uh, a follow up question with that is, can someone file bankruptcy individually? That means if their spouse isn't in agreement. So, if I'm married and I want to file for bankruptcy, but my spouse doesn't, is that an actual option where we can file single as opposed to doing joint bankruptcy in that regard?
Yes, there's nothing that says the spouse has to file. And sometimes if the bills are all in one spouse's name and there are no bills in the other spouse's name, you're going to want to do that because the other spouse will have a good credit report and they can continue on. And the spouse that has all the bills can not pay them. So you can just have one spouse file, and it happens quite often. A lot of times, though, the debts are joint, and it's just easier to have both file. Your filing fee doesn't really change much. Do just a few little extra expenses on, but it's almost buy one get one free. You get the husband, you're going to throw the wife in for very little extra costs. Attorney time's the same. There's a few little extra expenses, but not much.
Well, when it comes to that too, like you said, when people have joint documentation as well, I mean, they might as well file together because you're probably going to need both, all documents and tax documents from both individuals as well. So they might as well join you together so you have all that information.
Exactly. Unless one has stellar credit and the other one has terrible credit. So there are situations where you might just file one versus the other. Now, I do note, though, that if you only have one spouse filing, you're looking at the whole income as to whether or not you qualify to file a Chapter 7. There's one additional reason why people are forced to file a Chapter 13, other than just to protect assets. If you are making over a certain amount of money, the government feels that you have the ability to pay this back over a 3 to 5 year period of time, as opposed to just going into a no asset Chapter 7. And so, if you do not satisfy what they call the means test, you're forced into this payment system of paying something back over a 3 to 5 year period of time. You may only be paying 20 cents on the dollar, but you're paying something back. And again, this is to meet that um, where the rights of the creditors to be paid versus your ability to get relief intersect. And so what the government is saying is if you're making a lucrative amount of money, then you shouldn't just be walking away. You should be trying to repay your own bills. So there's a means test in there. Well, when you're calculating the means test, you're looking at the total income of the house. So I might be a husband that's only earning 30,000, and I have all these bills. My wife is corporate exec, and she's making big money. She's got perfect credit, but I'm going to look at the whole house's income, and I'm not going to qualify to file a Chapter 7 because the house's income is too much. Um, I'll still get out of my 30,000, but my poor wife is going to, you know. And then there's all kinds of issues. I've had people separate because if they're legally living separate, they'll. So sometimes the moral thing and the legal thing aren't always the same, and I can have a couple be living separate and apart with a separation agreement. And then they're already looking at the debtor's income. And in that case, I'm just looking at a $30,000 a year income. I'm not taking my wife's $100,000 income. combined. But I think just that's getting into the weeds a little bit. But just for people's general knowledge, you're looking at the total income when you're satisfying the means test for a Chapter 13. And so sometimes that might affect it. But generally, you do not have to have both spouses file, only one needs to file.
In terms of other questions, we've covered, I think, a very, very large majority of the main part of the bankruptcy process. So one thing that I want to add are just maybe some myths or some concerns that some people have about bankruptcy. And I know one question that a lot of people have is are bankruptcy filings or bankruptcy records public information? People feel very nervous, and I think I mentioned before, um, there's still, at least for some individuals, a stigma revolving around bankruptcy. So what does it mean when they file? Do they have to worry about records being public? Is it really anything that anyone should be concerned about at all if they're considering filing for bankruptcy?
Well, it is public record with the court. And so I always tell my clients, particularly in this day and age, the internet stuff cuts both ways because if something's public in the court, people are going to be more easily found. However, when people are looking at the news in the newspaper, they're not really, you're not going to see it in the local newspaper. Sometimes there aren't even local newspapers published anymore. And so, as a practical matter, in terms of general knowledge in the society, if you're not talking about it on Facebook, doubt that other people are going to be talking about it on Facebook. People are not predisposed to be nosing around into your business unless you are running for public office or you have some kind of high profile job. Then you would need to be worried about it. But most people worry needlessly because while it is public record, you either have to go physically down to the court to get it, or you have to know an attorney or somebody that can get it through the electronic filing system. It's not like I can just go online and look it up real easily. And then to get a credit report, that's private to you. And so, yes, it's public record, but it's not always easily accessible to the common person. And I think people worry needlessly about it.
Well, I appreciate you providing information, offering that for many individuals who are concerned. It is public record, but not to the point that, no offense to most people out there, but you're probably not important enough for anyone to really be digging into it in order to try to find it and have it worth anyone's time for it. Basically, the only way someone's going to know that you filed for bankruptcy is if you yourself are probably going to talk about it and share that knowledge with other people.
Most of my clients, they are well intended, but somehow or other they get on social media and the gossip of the town gets all over everywhere. And that's because they're blabbed it to somebody, not usually because we dug it up out of the public records.
I think we're almost done. I think we've covered most, like I said, of the core topics. So we're probably right at the end to wrap stuff up. Um, I think one important piece of information, if you could provide it, would be what are some options for people once they're actually done with the bankruptcy process to help repair their credit score if it's affected, and to help prevent them from going into debt again. Ideally, and I think this stands for a lot of people. After they file bankruptcy once, they hope they never have to touch it again. So, what are some options for people to prevent themselves from ever being in this situation again?
Very, very good question. First of all, there's a deterrent to that people cannot file a Chapter 7 again for 8 years after they filed the first one. In Chapter 13, they could file after 4 years, and then there's some other ways of in Chapter 13 of filing an earlier bankruptcy. But when people are commonly talking about bankruptcy, they're usually talking a Chapter 7, and I tell people that you cannot file bankruptcy again until 8 years. So there's going to be a little bit of motive to try not to do this again. But again, you can still get sick over again or get divorced over again. Some of the same things that caused them the first time. So we might not have everybody be Warren Buffett, but we do have debtor education course that you're required to take, almost like you take driver's ed, so that you don't, um, you don't build up points. You go get driver improvement. Some states like Virginia, you actually get good points. If you take driver improvement, they reduce your points. And so that concept applies in bankruptcy. So there is a required course before you get your final discharge that you have to take this educational course, and it teaches you how to manage money. So without being somebody to the sophistication of Warren Buffett, just a normal person is taught, for example, to try to have at least 6 months of expenses saved up, to have emergency funds saved up, to understand how credit cards work, how credit scores work, which is what your question is. How do we prevent this from happening? So I tell people, stay away from credit cards. As soon as the bankruptcy ends, you're going to get a pile of credit card offers. Why? Because they know you can't file again for 8 years. So they're going to give you credit cards. They're not going to give you large space of credit, but they're going to give you the credit card. And then your interest is a very high rate. It can be as high as 28% per year. So what I call them is shark loans almost with credit cards. Sometimes people might just get one singular credit card. And if you pay it within the 30 days, you're not paying that 28% interest. And what then you're doing is you're showing one-time payments and you're beginning to rebuild credit. And so people that are responsible with their credit cards that don't just run them all up can usually repair their credit within fairly good order. Within 3 or 4 years, their credit scores are going to go back up. Maybe not quite as good as they were before, but the bankruptcy will have less negative impact. It can stay on there up to 10 years, but it has less impact each year after the filing of the bankruptcy because it's 1 year away. You've been good for 5 years. It's like you've got 5 years of sobriety. You see, you're going to be better. It's going to have less weight on your credit report. And what has more weight than a prior bankruptcy on your credit report is debt to earnings ratio. Well, if I had $30,000 in debt and I'm only earning $30,000 a year, my debt to earnings ratio is terrible. But if I have zero debt and I'm making $30,000, well, I might not get a fancy credit card, but I might get one that has at least $500 of credit on it. So the debt to earnings ratio is more important on the credit score than whether or not I filed bankruptcy in the past. So what I tell people is when they file bankruptcy, we get their credit report and then we have a projection of what their credit report will be after 2 years of repair, and it surprises people. It goes back up quicker than people think. So I have people that actually can get car loans and houses and things relatively soon. Don't take the first car loans that they offer you the day you walk out of bankruptcy court, because those are those high 28% things. You must have anything away you get in the mail after you discharge your bankruptcy. But you can get a conventional loan for like a car loan, 6, 7, 8% after 3 or 4 years. The bankruptcy has a much less impact. What has most impact is your current spending habits. So you want to make sure that you are paying your bills on time. That's very important for your credit report. The length of credit that you've had extended to you, so 3 or 4 or 5 years out of bankruptcy, then you've got a good credit record, and now you're paying everything on time. And then the amount of debt you have versus your credit limit is very important. So if you have $10,000 limit on your credit card, but you only have $1,000 worth of debt, then you're a good risk because you're not pushing everything to the limit. But if you push everything back up to the limit, what's going to happen when you lose your job or you get divorced? You don't have that space to recover from. You're going to go right back into debt. So there are courses that are reputable that will teach you how to manage your money that are far more extensive than just the short course you're required to take for court. And I would recommend anybody who has filed do this so that they can be responsible and have enough reserves so that when the ultimate emergency comes, they're not faced with having to do bankruptcy And so part of what I do when people come to see me is I talk a little bit about them, about their spending habits. Sometimes that's the first time they see how they've really been spending their money. So it's an educational process, and then they can spend more wisely.
I appreciate you sharing that knowledge. That there are options, and it is an educational portion afterwards to prevent people from getting back in debt. And they are going to be on the other side if they just handle it correctly. You're going to teach them. They're going to be smart about it once they get out of bankruptcy, and there are going to be options paths that they can take to prevent themselves from getting back in and repair their credit score so they can return to living a debt free life. It's comforting to know that it is an option for a lot of people that they won't be stuck in this never ending cycle of bankruptcy. It'll just take a little bit of time to get there, but that's what the bankruptcy process is for, is to help them get to that point.
And that's what I like to do with my people. I like to think holistically. And so you can get a lot of attorneys that will just file their bankruptcy. But I like to have that personal relationship with my client. What I tell people is I'm their advocate to give them peace of mind. That's sort of, if you look at my website, that's my mission. And giving peace of mind isn't just getting their discharge in debt. It is holistic. It is to deal with a person's shame when they come in, to tell them that they're okay, and there are ways to do it better, and to refer them to the right um, sources. If it's student loans, then I can get them to a student loan attorney. If it's something about how they manage their money in the future, I can refer them how to do that, so that we're really looking at that whole client feeling like not only have they gotten out of their debt, but they've got peace of mind.
Is there any last piece of advice that you would like to provide any listeners or anyone looking to file bankruptcy before we end this video?
Yeah, to you can read up on it, but to get the advice of an attorney, you don't have to hire the first one you interview. You want to feel comfortable with that attorney. And again, just like in the criminal cases, the quicker you get advice from attorney, the better, because you might um, uh, get something filed before a garnishment is filed in the first place, rather than having the garnishment, then you run into the attorney, or you might forestall a foreclosure process. You might even work out with an attorney a way other than filing bankruptcy if you do it ahead of time. For example, in a foreclosure situation, there was often mediation particularly in Maryland, prior to foreclosure, and you can work out a forbearance plan. You can work out a way of scheduling out the debt without having to file bankruptcy. If really the foreclosure is the main issue, you don't have other credit cards and things. But if you're waiting until the hammer comes down, it's too late. Then you're going to be pushed into the bankruptcy. So I would always say, in almost any aspect of the law, but particularly in bankruptcy, get to the attorney early on, because there are options other than filing bankruptcy that may work better, that may be foreclosed if you wait too long.
Great advice. Don, thank you very much for your time and for providing your words of wisdom to everyone. And we will be back at some point in the future with another video covering some more legal topics.
Very good. It's been a pleasure.